Hello, this is Chapter 7. Our topic is liability in student records. The primary purpose of maintaining student records is to aid school personnel in developing the best educational program for each individual student enrolled in our schools. Student records can include counseling information, program development, individual instruction, what grade students are in, college admission information. So those are all the things that could be involved in student records. So as our slide here says, Public Law 93-380, which is FERPA, protects the confidentiality of these records. The FERPA Act is sometimes referred to as the Buckley Amendment, enacted in 1974, and it gives the confidentiality to parents and students so that there is fairness with respect to how these records are maintained and how they're used. The law was designed to ensure that certain types of personally identifiable information regarding students is not released without parental consent. However, if a student is of the age of 18 or older, or is attending a post-secondary institution like college, parental consent is no longer required. Since this law, FERPA, is a federal statute, it applies to school districts and schools that all receive federal funding. Schools should have policies and procedures in place that are available to parents upon request. They are allowed to know what types of records the school is maintaining and keeping, and who is responsible as far as school personnel for maintaining and keeping those records.
Sanctions for violating family privacy rights. So kind of like Bridget said, student records' primary purpose is to aid teachers and administrators in creating instructional programs that meet the needs of the students enrolled in the districts. Records show grade level, family background, health records, progress reports, attendance, discipline, and the FERPA law protects confidentiality of student records. There's an excerpt from the FERPA Act that states, at a minimum, the school district should provide on an annual basis information to parents, guardians, and eligible students regarding the content of the law and inform them of their rights to file complaints with the Rights and Privacy Act Office of the Department of Education. If non-English speaking parents are affected, the district has a responsibility to notify them in their native language. Districts should annually provide information to parents, guardians, and eligible students. Educational records should include records, files, documents, and any material that contains information directly related to a student or the materials maintained by an educational agency or institution. They do not include instructional records, supervisory records, or records from law enforcement or post-secondary information on 18-year-old students.
All right, so I'm going to talk about the rights of the parents. Parents or legal guardians have the right to inspect their child's records. So anything that the parent finds in there that they want to challenge the accuracy of within the file, I mean, they have the right to do that. A meeting should be set up within 10 days. If the conference can't solve the concerns of the parents, there should be a meeting that is set up with, I think the book called them like the director of pupil personnel. That meeting should also be set up within 10 days or less. If they are deemed accurate, you know, the stuff in the files, the parent should be notified, and the documentation the documentation of the findings should be added to the file so that when it is, you know, sent somewhere, it shows that these things that are in the file are accurate. The parents can also appeal to a court if the records are subpoenaed. The parents and the student should be notified. And then it says a school official should be present to assist the parent or guardian in interpreting the information contained in the files and respond to any questions which may be raised during the examination process. One thing that the book did talk about that is if there is consent needed for the records to be released, there needs to be a written record that contains the name of the person consenting to the release of these records and the date. One other thing too is that these records should never be shared. The one kind of exception is if a student is going to transfer, the school district that they are transferring into has the right to these records. But the one thing is the parents have to notify the school that their child is transferring to whatever district it is, and then that district has the right to request those files, and the school can send them over. So I'm going to talk about the rights of non-custodial parents. So it says occasionally controversy arises regarding the rights to a non-custodial biological parent to access his or her child's educational records. A school district policy should provide guidance in these situations. There was one case, I think it was in New York, that a mother tried to have the school not allow the records to the child's father. The father took it to court, and the court sided with the father, and it said that the child's records should be accessible to any parent, whether it's non-custodial or custodial. And they said the reason for this is this child is fortunate enough to have both their parents' interest in their education, so they should have the right to access these files, whether they are custodial or non-custodial parents. I'm sure every school district has a policy that's in place. I know my school district does, and I'm sure most other ones do too.
Oh, sorry, that's me. Okay, so the rights of our students, the students can also do the same thing that their parents and guardians are doing, only if they have reached that age of 18 or if they are in like a college type of class. So if they want to look at the records that are in their own file and they're of that age, they have the same rights to do so. So they can inspect, they can challenge, they can decide who has access to their records, they can get copies, they get due process for all of those kinds of challenges that they want to do. And anybody that is examining a student's records your school district should have a form to examine records. And that form should say the name of the person, the title of the person, the date, the time, the interest, and what specifically they were looking at. So there's a record of who's been in the student's records as well. Any kind of corrections or adjustments would have to be done with the knowledge of school officials. So it would have to be done with a group of people. If for some reason someone was going to call on student records, maybe a student is applying for a job or saying on a resume later in life that they graduated from this school, and an employer is calling to check on a graduation or something of that nature. It did say in our book that they highly recommend that schools do not provide any information over the telephone. The rights of school personnel. So this is going to be your teachers and other school staff and what rights they have to look at student records. You can do that if you are a teacher, counselor, administrator. There is a form that I just discussed that would go in the file that says who was looking and why. So that's that same form that I just talked about. In 1994, FERPA was amended to emphasize that institutions are not prevented from maintaining these records for disciplinary action. Most of these student records used to just be grades and demographics and that sort of thing. But in 1994, they started talking more about discipline.
So I have confidentiality issues involving school counselors. A number of states have passed laws protecting the confidentiality of school counselors, but not all or most states do not have this protection. Most communication between a school counselor and a student does not rise to a civil or criminal proceeding. In states where no privilege is granted, the counselor is required to testify if ordered by a court. Records that the counselor keeps are not subject to FERPA. School counselors are not required to share the information with the student's parents, but confidentiality may be lost when public disclosures in the public interest. There was a case, Tarasoff versus Regents of the University of California. A male student told his psychologist that he was going to kill another student. The psychologist warned the campus police, but did not warn the other student. And then the first student ended up killing the student. And so the parents went back and they said that since the school psychologist did not warn that student, that the California Supreme Court ruled that the psychologist did have a duty to warn her. And so she would, it was kind of on her that she didn't tell the other student that somebody was after her, I guess. So just making sure that you know like who to tell, and then documenting that and informing all the right people.
So I had enforcement of state or federal statutes. So federal official and state officials may inspect files without parental consent in order to enforce federal or state laws or to audit or evaluate federal education programs. So that's a little bit of a change. They can look at those things without getting the consent of the parents. In these cases, personally identifiable information may not be associated with any student unless Congress by law specifically authorizes the federal officials to gather personally identifiable data. Information can be released without the consent if it's in connection with an application for student financial aid. So kind of like how we were talking about earlier, if a student is trying to get into a college or you know, apply for some sort of student financial aid, it can be released without the consent. So the authorized personnel that can access records, they may include the, I don't even know how you say that, Comptroller General of the United States, the Secretary and Administrative Head of an educational agency, and the state and educational authorities. One thing that the book did talk about, says that school district policy should address this issue beforehand, so parents know that this is an exception. It's important that they know that their child's records can be accessed without consent by these people. I'm sure, like I said, that this stuff is in most schools. I'm assuming that they will address these just to make sure that the parents do know that this is a possibility.
And one thing also I would like to add is that the book did make it clear that in these records, there should be an avoidance of putting labels on students and being careful with wording when you're doing all that documentation. Okay, so privilege. On many occasions, school personnel are requested to provide either oral or written information about a student. That's something that might be in their file. Brooklyn talked about privilege a little bit earlier on. When these requests are made, you have to respond in a truthful and reasonable manner because you are protected under qualified privilege. But you should avoid, when you're doing that, labels. If you're asked about discipline records, should also have very specific information, time, place, witnesses. And it did say for behavioral or discipline records that the student should be present when those records are being written and made so that they know what is in their discipline record.
Good faith. Qualified privilege is based on the premise that the educator is operating in good faith when damaging or sensitive information is communicated to others who have no need to know. Good faith has been violated. Good faith requires that a legitimate purpose be served by communicating the information, and common interest in the student's well-being would constitute a legitimate purpose. So there was a case in Maryland that addressed good faith. A special education student was sexually abused by her grandfather, and he was charged with child abuse. The grandfather tried to subpoena the granddaughter's records prior to his trial. The district refused to give up the records and filed a protective order. The judge examined the records and determined that there was nothing in them that could impeach the child's testimony. The grandfather was convicted, and then he appealed, stating that they had violated his rights and didn't allow him to the granddaughter's records. But because the lower courts had ruled that there was no information in the student's records, that he needed material evidence, and therefore his appeal was denied.
So I'm going to talk about acts of malice. So malice exists when there is an intent to harm or injure another. There are two forms of malice. One is implied malice, where the offender has no defense for conveying harmful information. These statements normally fall under the category of unsolicited or derogatory statements aimed at another person. And then the other form of malice is actual malice. This is where the offender or the offended person must demonstrate that the person making the offensive comments had a motive for doing so, and that the motive was calculated to generate ill will against the offended person. So when statements are communicated about a student, either written or orally, with the intent to injure his or her reputation, a torturous act has occurred, especially if these statements are false. One thing that they did say is truth is a defense for liability if no malicious intent is present. So one thing that the book talked about is said is even if the statement is true, if they can prove that the school acted in bad faith and they had the intent to injure another person's reputation, there can be legal action taken. So even if what these people or the school personnel said was true, if they can prove that they did this with the intent to injure their reputation or, harm it within the school, they still can get in trouble for it. It says school personnel should exercise care in ensuring that the statements communicated to others are free of malice, based on defensible evidence, and communicated in a professional, non-biased, and truthful manner. The students are entitled to the liberty right, with the respect to the exception that their reputation is protected against unwarranted attacks. So these students, they have the right to not have their reputation harmed because of what somebody is saying about them. So that's it. I think, does anybody else have anything to add?
A couple of things to add about school records. The book did also say that they should be kept safe and secure. They're never allowed to leave the school premises. If somebody calls the school asking for school records, like a prospective employer or a college, you're only supposed to give them the information they're specifically asking for. So it's probably like dates and diplomas and that kind of thing, really standard issue kind of stuff. I thought there was a couple more court cases that were interesting. Things just to think about when you're going about your daily business of running school. But when it comes to grades, the courts have said that it is inappropriate and it is not supported to publicly announce student grades. So you're not supposed to ever share someone's name with their grade. There have been cases where parents have gone to court to try to get student records. So there was a New York case where a father of a third grader wanted to know all the test scores of all the students in the third grade because they obviously had their own child's test score, but they were trying to compare their child to where they were in the class. And so they, of course, needed everyone else's test scores as well. The court allowed it, but no names were attached to any of the scores. So they were allowed to get student records of other students, but with no names on it. And that seemed to be fairly common in some of these. The other one that I thought was interesting was a school board member during a school board meeting had mentioned that there was a student in their school that was caught with marijuana cigarettes in their car during a meeting, and they got dinged for that because that was privileged information that should not have been shared in an open school board meeting. So it's always a fine line of what you can say and what you can